So your injury lawyer calls you up and says, hey, the other side is stipulating to liability on your injury case. And you're like, fantastic. And then you're thinking, is it really that great? How's it going to affect my case? What is it? Well, if you want to learn more, come join me. I'm doing a little hike here in Hollenbeck, here in San Diego in the foothills. And if you want to know the ins and outs of what stipulated liability really is and how it can impact you on your injury case, well, come join me. Welcome. I am San Diego personal injury lawyer Mark Blane, practicing law here in San Diego. And stipulating to liability sounds like a big fancy phrase, a bunch of legalese. What it means is that the other side has decided to admit fault on your case. And here's how it plays out. Depends on the case, but sometimes the defense doesn't admit fault in your case until right before trial. They do this for various reasons. Some of the reasons just don't have any logic to it, but the whole goal is that they want to come across later, if the case does go to trial, as being repentant to your injuries. So they can tell the jury, oh, we've admitted fault. We've admitted fault on this case. And they try to infer that maybe you weren't being reasonable or something. So that's the whole goal behind it. That's the sneaky factor that the defense does. And the timing's all about it, right? So what I do is I never stipulate to liability. The defense, I tell the judge, the defense can admit to fault to breaking the safety rules all day long. That's great. I'm never going to stipulate to it, because a stipulation means two parties agree. That's a stipulation. Like I said earlier, they can admit to fault, but I'm not going to stipulate to fault, because here's why. If I stipulate to fault, what the defense really is trying to do is not only look repentant, but they're trying to exclude testimony of the wrongdoing. That's really where it goes. That's the heart of this deception, is they're trying to not bring in testimony about what their defendant did that was wrong. Think about it. If they tell the judge, hey, Judge, we've stipulated with Mr. Blane that we're admitting fault, then at some point, if it goes to trial, the defense can't bring in testimony of the wrongful act, of the car crash, of the rule violation, of the choice the defendant made to be unsafe, which led to my client's harm. That's really what it's all about. And so I tell the judge, they can admit to fault, but I'm still bringing in evidence of everything that happened to my client, because the jury needs to weigh it and make an informed decision based on all factors, good and bad. That's a fair fight. Otherwise, it's not a fair fight. And what the defense is trying to do is handcuff the ability of me to argue the case properly in front of the jury. And that's what I tell the judge. So whenever you see stipulation of liability, with me at least, I'm not ever agreeing with it. And the other thing is, it's up to the jury to make the decision based on all the factors. And that means that they need to hear about the wrongdoing, because at the end of the day, if the defense is able to stipulate to liability, they can just say all day long to the jury that they admitted fault. We're trying to be reasonable. But really, it's fake. It's fake repentance, because if it was true repentance, you know, my grandfather told me there's 3 things you got to do to make something right when you do a wrong. Number 1 is you got to admit that you're wrong. And then you got to apologize. And number 3, you got to make it right. You got to pay up. You got to make it right for the person that you harmed. That is the social contract we all have with one another. And so if the defense can utilize this notion of stipulating to liability, they're only doing one of the 3, which is basically admitting that they're wrong. But they're not apologizing, and more importantly, they're not paying up the true value of the case. So that's where they're going. That's the secret. That's the secret sauce in this defense tactic, I call it. It's really a defense tactic. They research this and they know what they're doing, but hey, good experienced injury lawyer knows what they're doing too, right? So we're the equalizers. We make it right for our clients. So if you're probably asking yourself, well, Mark, why are you sharing this information? Well, maybe you have an injury case in California and you need a good lawyer, or you just need to pick a good lawyer's brain to see what options you might have on your case. Well, I make myself open to anyone. I invite you to email or call me. My phone number is 619-813-7955. You can also email me at mark@blanelaw.com. That is B as in Bravo, LANELAW.com. And I'm happy to help if I can. So keep that in mind. Always here to help. So that's it for the video. You guys have a great day. Thank you. Hi guys, thanks for joining me on this great little walk in the woods here in Hollenbeck Canyon. Just want to say I had a great time making that video for you. And remember, I'm here for you on anything. I've got free information downloads, ebook, injury guides, survival guides for any particular injury in California. So if you need a free copy of that, just head on over to blanelaw.com. That's www.blanelaw.com. And here's one as example, 10 Secrets book. I got a few other ones, so take your pick. And again, I'm here if you need me for anything. And that's it for the video. All right. Well, I hope you have a great day. Thank you so much. Bye-bye.